James. Get back in here, Brandon.
Oh,
Just-
sorry.
just
Yeah,
start.
sorry.
All right. It's after 5:30. Let's get started with the, this, policy committee. And we'll start off with, policy, headlights. You wanna go with that first? That's one of the top on my list. I'm getting some top on mine on the bottom there.
It's on top of mine.
Okay, one we're working on.
Oh, here.
All right, you ready for me?
Yes, sir.
I
You
think-
and our super duper nurse back.
Very good. I may have to yield on this one to her, but let me frame this. We have some board members that were not here this time last year. We do a reset every year. I know Barron wasn't here previously, but we contract with TSBA for our board policies. Their attorneys make recommendations on policies. I don't know where Barron is, he's not even in here. They make recommendations on our board policies, and then every year they go through and identify policies. They send us a list of those, and that's what our committee reviews and updates our policies from. So Tiffany got these, I guess, last week, or the week before last. We called the policy committee, and then there's occasions when some of our current policies get reviewed, but the majority of these are straight from the TSBA list because it's time to review. This current one, Pediculosis or head lice, we're gonna start on a 6.4031. And on this, I may have to yield to Nurse Roz even for the pronunciation, but I'll use the common terms. But the recommendation for the committee would be to add, not just head lice, but go ahead and add C-Mex, Lictarius, or bed bugs. Is that how you say it?
Come on, Ron.
C-Mex, Lictarius, or bed bugs to our policy, because that is also a common occurrence within schools. Our kids come in with these on their persons or in their backpacks, and it's treated much the same as head lice. There's laws and regulations. This isn't what does Roane County schools just want to do with kids with head lice. We have to follow prescribed rules and things that are impacted through the law, because it is a student right issue. We want to treat it with discretion. We don't want to humiliate or embarrass any kids. So on this policy, if you'll bear with me, the policy on the left is the current policy. The one that I'm recommending to update would add in the descriptor of the term on the top, you would add whatever the pronunciation is, bed bugs. And then in line number 1, we would add it after the word and, we would add or bed bugs. If you go down to line number 5, after head lice, there we would also add or bed bugs. And then later on, down on line number 9, where it's the bullet point number 1, proof of treatment, and then we would add for head lice or bed bugs, and then so on and so forth. Down through line 13, we would add the bed bugs language there. Line 14, add bed bugs. 15, bed bugs twice, and be found free of lice or bed bugs, and later in line 15. And then on line 17, 2 days following the exclusion for head lice or bed bugs. So all we're doing is keeping the policy identical, and we're adding bed bugs everywhere we're talking about head lice, because it's interchangeable.
Our current policy, all we're doing is wherever it says lice, it's also gonna say bed bugs.
Correct, lice or bed bugs is all, the only changes we recommend making. And, of course, the attorneys at TSBA were good with our old policy, and this has been the policy since 2013. So if we approve this and it goes through 2 readings of the board for the new board members, we go through the first reading, and then it becomes policy after the second reading of the board, the full board. But I recommend we add add the bed bug language and move from there. Is that good for you, Nurse Ross?
Ms. Virgin brought up that there's not a treatment listed for the bed bugs. Is there a shampoo or a treatment?
Line 9.
Is it on that one?
It just says in line 9, it's parentheses, head lice shampoo. But if we're adding bed bugs, do we need to
What's
have
the
proof
proof?
of a bed bug treatment?
There's a pediculosis product, some kind of product, is that also used
I don't
in
know
treating
if
bed?
there's one for bed bugs in particular.
So how would we,
Let's see.
yeah, without that proof?
I just don't know how you could prove that they have treatment for bed bugs.
That's basically your whole house.
And
Yeah.
yes,
That's,
A licensed exterminator, it says.
I mean, you have to have an exterminator to treat bed bugs.
Yeah.
Not
Oh, yeah.
shampoo. Right? I'm pretty sure.
you're looking at the wrong guy, buddy.
You just look like bed bugs, so that's why I'm looking at
It depends on,
I could just see them asking, well, I have lice, you say, you know, proof.
No, I think
But
it's
if you send them
different.
home for bed bugs, then how do we let them back in?
I don't know that answer. But I also don't know how you can
Ross?
prove they treated for bed bugs.
And that's longer than a 2-day
see,
process.
Right.
but, I mean, how often,
That's a couple of weeks.
How is,
that's
I
still,
guess my question is, how is bed bugs transported?
oh, on your stuff, you can get them from the grocery store, on that bag.
Backpacks.
Backpacks,
Lunchbox.
anything, there's, bed bugs is common.
Well, just, I didn't know how they was transported, that was my.
They
They
just
got
attached
off to my
to
house
stuff.
on a backpack, it took 1 week.
Backpacks.
We were out of our house for a week.
Shoes, just anything, they attach to anything. They're,
Okay.
yeah.
Yeah, these, what, I can't even say the word, do not treat, kill bed bugs, so the things that you would typically use, like permethrin or ivermectin, are, good for scalp and skin, but they do not, they do
Recommended.
kill lice, but they do not kill bed bugs in the home. Generally, bed bugs, it's acting like the bed bugs just live within the home and not on the human, although we know kids have them on them, but they don't live and feed on the host like a head lice does. They live in, whereas bed bugs hide in furniture and only emerge to feed. Lice live on people, and that's just a quick Google search. So should we look to bring that one back next month's meeting and with a little bit of clarification on treatment?
I think so.
Okay. We'll move to the next one. I've got appeals to and appearances before the board. That's what I'm looking at.
This one starts us right back over section 1 of our board policies. This is appeals and appearances before the board. As you'll see on the, if you'll separate the 2 pages, the left is our current policy, the right is the recommended updates from TSBA. If you will go down, no changes in lines 2 through 7 recommended, no change on line 8. And then if we go to 9 through 14 on our current policy, they're taking the lines 13 and 14 out where it says members of the board and the director may have the privilege of asking questions of any person who addressed the board. They removed that and they put that back to the responsibility of the chair. And then they've made a change on line 11, whereas before the TSBA recommended having the person speak, state their name and the subject of the presentation. That's what all they're asking is for name and subject of the presentation. They have stricken or recommended to strike on number 11 of our current policy the word address. So each person speaking shall state his or her name and subject of presentation. So this recommendation from them is to remove address. If you go down to line 15, during the public comment period, this is talking about lines 15 on the new policy, 16 on the old policy. There shall be a public comment period for each meeting with actionable items on the agenda. That's new language. Previously, it was just for board meetings, but if we have actionable items on the agenda, they recommend doing a public comment meeting. With the exception of teacher disciplinary hearings, and comments shall be limited to topics listed on the agenda and matters that are germane to the school board's jurisdiction. Now, the old laws were, at one time, it was that they had to be germane to the items on the agenda. Now that, due to a change, they are recommending that anything that this school board has authority or control over, that would be your jurisdiction, then people wishing to address the board can speak on those items. The total public comment period shall be for no more than, and it says insert amount of time. We have discretion as a board to set that amount of time, and we're talking about a cumulative time. If we had 7 or 5 people that want to address the board, and we stayed with 3 minutes each, then we may say 15-minute time limit, 20-minute time limit, but we can do that within this policy for the total amount of time. And then it says if an individual wishes to address the board, he or she shall sign up on a form provided before the beginning of the board meeting to request a time to speak. Each speaker shall be given no more than, and we have some discretion on that. Currently it's 3 minutes is what's in our policy. And then delegations shall select only one individual to speak on their behalf unless otherwise determined by the board. That's similar to what we've always had in place. So, if we adopt that, we're gonna have to come up with a total amount of time to designate it in each meeting for public comment. We're gonna have to decide whether to stay with the 3 minutes, and the rest is just to move it over. And then, well, in the form portion of it, Tiffany provided some examples from a couple of other school systems. And honestly, we thought some of theirs were too cumbersome. We don't want it to be an inconvenience with people that wish to come and address our board. We want it to be a simple form. So the example, we had a couple of other districts. I won't say them out loud, what districts we use, but you'll see that first form after the, she has done a copy of the TCA that talks about speaking to the board, and then she did a draft form right there on 1404.1, so that would accompany the policy. And all it does is it talks about the 3 minutes, if that's what we choose to do, and it talks about designating a person. All they have to do is put a date, name, and the subject that they want to speak about. And that just helps us have order within our meetings. It's not, and it can be filled out immediately before the meetings. It doesn't have to be done in advance. There's no restrictions on that, but it'll help us schedule some time. So then we go down to lines 23 through 28 that are recommended language. Individuals desiring to appear before the board shall submit a written request with descriptive. Now this is not people appearing before the board. These are people like entities. If we had the Roane County Anti-Drug Coalition that wanted to show their numbers that they've been working in our schools, then they would have to do a written request with descriptive materials to my office. And I would recommend 10 days prior to the meeting, because Tiffany has to have the notices out and published within 7 days. So that blank right there would be saying within 10 days before the meeting. And if the request is approved by the executive committee, then the item will be placed on the agenda, okay? And then the individuals will be recognized at the beginning of the meeting and given their time to speak and present their part. But that's it. That is the only additions, and it's just clarifying what we've always done. If we've had entities from wherever, other government entities or whomever wanted to appear before our board, they've always gone through Tiffany's office. And this just puts it in the
If
policy.
we're gonna have somebody come in, like we had the gentleman come from COM and
Yes.
spoke, what kind of time frame would they usually be?
Well, we talk, and that is actually part of this. We have to decide on how much time to allow. And I think we need to use a range of time, because there's some people that need literally 1 or 2 minutes, and then there's some, if it's something, somebody we're doing a program with or whatever. policy recommendation, we were sort of excited about it because, people don't understand. Tiffany has to pull all this together, post it online, and give adequate notice. So some people like to, sometimes they get rushed and they want to pop it on us last minute. Well, it makes us look like we're not giving adequate notice and we're trying to hide something. We're not trying to hide something. Things get sprung on us all the time. So that's why we were recommending 10 days before the meeting. You know,
What I'm saying, these people, that's taking time to meet with committee and so forth, and they put their plans together.
yes, and they can have their presentation done, you know, a month in advance, but they can't get on our agenda unless they give her 10 days notice. That way she gets time to put it before the executive committee, make sure it gets on the agenda, and then still provide the 7 days
Okay.
notice to meet the guidelines. And those are the changes. So basically the difference, if you want me, that's a lot of words to say.
About 15 through 21.
Yes.
It says there'll be a public comment period for each meeting with actual items on the agenda.
Correct.
So is this saying they can only address the board about agenda items?
No, previously, people have ruled that was an allowance in the structure, but now, what they're recommending is they can comment on anything germane to the board's jurisdiction.
Which is what we do now.
Right, they can't come in and talk to us about, gas and oil prices somewhere else unless they're gonna relate it to transportation concerns, but they can talk to us about anything that falls within the policies of this board, I guess is the best way to explain it.
So then our comment period is not changing really, except we don't have to know their address now.
We don't have to know their address, and then they need to, when they come in, they can request it in advance, or when they come in, put their name, date, and the topic.
And we've
They don't have to
never
write a
done
book.
that, have we?
No, and a lot of systems have done that and made you do it so many days in advance. Our board elected to let people come in and appear before the board. This is just putting it on paper. We can add that to the minutes of the meeting. We have that, and it also just gives us some form of control over proceedings. And if there's a stack that big over a controversial topic, then the board can immediately move to expand the amount of time and say, hey, I think we've got a lot of people interested to speak, let's expand the amount of time. But until that, we need to insert an amount of time for this portion of the program, and then we need to decide whether to stick with 3 minutes or to change that.
And that's right here where it says the total public comment period shall be no more than, we have to pick a time that everybody's gotta be done talking?
You can pick a maximum amount of time that we
Yeah.
So you can say 30 minutes, and you can break it down amongst.
So if we say 30 minutes. what
That
if we're
gives
not- what if
10
we're not through it?
people.
If we're not
They
through
get
it,
3
then you
minutes
still.
to speak, and
You
that would
can-
mean if you got 10 people.
You could elect at that point to add additional time.
Can you elect to cut the time?
If there's nobody speaking, you would move on.
Yeah, you wouldn't wanna do that if there's people waiting to speak. I wouldn't recommend doing that.
I mean, if you had one person that wanted to speak, say Miss Mandy Evans wanted to speak, and she got up and spoke, and nobody else had anything to say, then you'd go to.
But I mean, that don't give her 30 minutes to speak.
No, she still just has 3
She would
minutes.
still just have 3
Or
minutes.
whatever.
Because she can talk for 30 minutes.
Oh, I believe that, I've watched it.
So
I
we're
will
finding it's
say-
still 3 minutes, is that?
Yeah.
Well,
Maybe we'll have to.
we'll have to
That's
insert
one
that
of the
amount, it
Yeah.
says.
I mean, is 3 minutes really enough time for maybe?
Yes.
Yes, it seems like
Yeah.
an eternity.
Yeah.
I
I
understand.
will say at the board secretary, conferences that we have with the TSBA, a lot of the school systems and secretaries that are there, they do that form, and their comments have been, it just helps the meeting flow better, it's more organized. Now, some of them require them to send it in, 10 days prior to the meeting or whatever, but, I just think filling it out, we'd have the podium out there with the sign, they fill it out, and then they have to turn it in to the chair or myself prior to the meeting starting. So, they like that process, and two, for me, a lot of times when people speak and they have to give their name and address, it's hard for me to hear and understand.
And you'll have that information.
And that way it's written down and I have that, so it will be helpful to me as far as doing the minutes also, that it's accurate.
But this won't have address anymore, it'll just be
Yeah,
name and dates.
just name and their,
And the last line says delegation shall select only one individual to speak on their behalf. Does that happen? How do you enforce that? You gonna tell somebody they can't speak?
Well, you can,
I would not, or is that what we're saying?
no, but you don't want, if you got, and I'm gonna use Auburn Springs Alumni Association here, if they come down and they gonna talk to you, they shouldn't bring 5 people to tell you all the same thing. They ought to have
Yeah, I
one
get
person.
that, but we're not talking about the alumni associations. I don't think that's the issue that we have.
But they need to be able to.
Okay, here's an
differ their-
example.
Differ their
We
comments
had
and examples.
21 people here to speak on books. Do you let all 21 of them talk? Or do you pick one and say, that is your delegate? You got 3 minutes. That's what I'm asking. I don't know the answer to that. It's in here. How do you do it?
Yeah, that's been in that was in our old policy as well, but I don't know. I mean, there's people that, if they're talking about different
I
things.
mean, the way we're going, I'm good with, the way we do it. I want everybody to talk. But if it's in policy that they can't talk, and policy is what we follow, then they can't talk. Does that make any sense?
Well,
I'm good if everybody talks.
I don't mind that.
I mean, that, I don't know, it just seems like
As
something.
long as we
you
do it in
can't
a
enforce.
reasonable fashion, don't.
Okay, I'm good.
I think at that point, the decision, chair, right?
Yeah.
He'd be able to say, they put it up at the same time.
I'm good.
So you could remove that, the limitation on the total amount to speak, if that's something that you do not want to have in there, and then just keep it 3 minutes per person.
I just don't know how you could say in 30 minutes we're gonna be done,
Yeah.
if there's
Well,
still.
But one thing you could do is after, say 30 minutes, you still have 10 people there to speak.
You could
You can
extend
always,
that time.
you can extend that time.
Yeah, I'm good either way, it doesn't matter, I just,
That's, you know,
So someone would need to put it in the form of, accepting the changes as recommended by TSBA and inserting total amount of time, and then whether to decide on the 3 minutes or not.
so I'll make a motion to accept, insert 30 minutes, 3 minutes for each speaker.
And I'm sorry, let me add one more thing. And are you also with the 10 days for individuals that want to present through the agenda?
And the 10 days.
Not second.
And the simple form that they can fill out.
Yeah, the form is
Yeah.
included in this,
People
right
who
here.
wish to speak
Yeah.
at the meeting, not any limitations on when they have to get that in.
That is the motion.
that's your motion.
I said,
You got a second? Robert, second. All in favor, say aye.
Aye.
All opposed? All right. Oh, what you got now there, Mr. Finn?
Okay, we're moving to 2.400 revenues.
Okay.
This one, should be a lot fewer changes. Of course, this is recommended by TSBA as well. If you'll go down, no changes recommended until after line 16. Extended school funds shall be collected at the individual sites, receipted and deposited into the appropriate bank account. That is the same. The principal shall report the collections and pay to the board by school check. So, in other words, they're gonna collect the money, deposit in the school accounts, and then the school will cut the check to the board, because the schools do not pay payroll items, they come from the central office, so it's, let me see. Moving to the second page, we have some decisions to make. Currently, we do not accept online payments, and if we were to do that, we would have to add some language here on line 6, and so I guess we would have to, as a committee, decide whether to change that.
So we don't allow online pay, we
Well,
don't accept.
we have two things that are online. That is for the cafeteria meals that are done online, and also on the sports, the Go Fan account are the two that are currently used, that we would still like to be able to use those. But as far as anybody using Venmo or PayPal or any of those, we do not want to open up that. Yes.
So with the online payment, we would have to look at version number 1 of the recommended changes. Approved district staff may utilize and insert the title of vendor for electronic payment. Processing fees for these transactions, we would have to look at shall or shall not be charged. And then the bottom part is rounding in cash transactions, and that is in response to doing away with the penny. So we would have to adopt a policy where we talk about the rounding up or down. Lance, do you know the name of the?
The cafeteria one is My Payments Plus. And the other one is Go Fan.
I think it was.
And the other thing, if you use it, you really don't have an option on saying whether or not there's a service fee, because it's automatic. So if you use it, you're gonna do it.
The processing fees for these transactions shall.
Yeah.
Non-payment plus has processing fee.
Yes, they do.
And then the legal references have changed as well, so, no, I'm sorry, that's just a new section. From your current policy on page 2, under line 7, we would have to add the collection of funds through online payment and add the My Payment Plus and Go Fan for electronic transactions. And if at some point in the future, the board wanted to add another payment plan for something, or wanted to move away from one of these two, we would just come in, bring it before the policy committee and change those two.
Just a question about sports, basketball, football, playoff situations. Because sometimes you see that where you have to get a ticket through online for TSBA or something like that. Is that here in this policy?
I don't believe you're paying the schools at that point, are you?
I don't know.
I think you're paying TSBA, TSBA,
The school, yeah. TSBA contracts with GoPay, so it goes with GoPay.
Is that what we've already talked about, the same thing?
Yeah.
Okay.
There are other athletic ticket options that are out there that some of our schools have talked to. There's several vendors, but I think GoPay's the one that we traditionally use.
It's usually private schools that, that maybe we played or something, that the parents or people coming up, you take cards, I'm thinking like King's Academy, that was one that, it's like, and I'm sure they got a lot of, students, maybe from other countries and that kind of thing, but they have cards and at, baseball, wanting to use a card at the concession stand or something like that. So we're not,
We don't have any card readers.
we're not doing that anywhere.
Is that something you said is too difficult, we don't wanna try that?
That's not been something we've discussed as far as concessions or having cards at. Yeah.
There you go.
On this one, back on that first section on the extended school programs, that would be a program change for us. Currently, those programs collect their own funds, and submit those to a bank account that the trustee has control over already. So if you add that line in there, that would be a program change. Also, on the electronic stuff, another option to consider would be, could be utilized at the discretion of the director or designee. That way, if there was a change to those two platforms that we currently use, it wouldn't be a policy change every time that was happening.
And for clarification, person, correct me if I'm wrong, Derek, but there's been rumors that some schools are trying to go cashless. You cannot go cashless. I think that's forbidden in the state of Tennessee. So you can offer it as an option to do online versus, but you cannot require it. So we want to be respectful of that.
Somebody like that, they talk about going semi-cashless, I guess, offer that option, or is that, you said you got the, offer that, but most of our high schools are, for example, Coach Jay, talk about these all the time, speaking on social media, about you go ahead and go fantasy now. Yeah. And we have several of our high schools specifically for football and basketball. I know charity.
And like I said, there has to be that cash option. You can't say only do it this way.
I just had to go somewhere where it's only cash, cause I gotta watch 3 kids, if I have cash in around, it's yanking. I think it's something we will, when I meet with athletic directors, 2 times a year, it's a topic that always comes up, so certainly we can discuss more about. There are a lot of people that like that option more of it. Some people don't want it at all, I get that, but it's something we can discuss more with them.
Wouldn't mind, Derek, will you clarify, do you see that as an improvement or a hindrance on the program, the base and stuff, doing this through their payment?
On the extended program, I think that would be an hindrance to our current operation. I would not suggest to add that. On the electronic funds, personally, in our office, we would not suggest to add that because you need to look at internal controls and make sure that we follow all of that before we just make a decision on accepting electronic payments and then worrying about the controls after the fact. So currently, I would not suggest that.
So do we need to study this further?
You could do that, yes.
So there's a legal citation at the end of line 16 on the new line that they're asking us to consider.
Check that out and see what it is.
Yeah, I think we're gonna get backwards.
Make sure it's study up on that. Moving to student wellness.
Student wellness, 6.411. Several changes here recommended by TSBA. Line 6, all schools shall implement the Centers for Disease Control and Prevention, CDC. They're asking us to strike that language and leave coordinated school health, CSH, program for wellness-related programs and services in schools. And the surrounding community based on how state law and state board of education coordinated school health standards and guidelines. The school district's coordinated school health coordinator or supervisor is the language that they want to add there, shall be responsible for overseeing compliance with the state board of education coordinated school health standards and guidelines. So in other words, the state is going to, apparently, there's no sense in putting the CDC portion in there because it's up to the state to change their guidelines of being not be in conflict with the CDC, and then therefore, we as a school district in the state have to comply with the coordinated school health standards. If you go on down to line 16, and line.
Before you go there,
Yes, sir.
you got a line striped through 3.
That they removed that, TSBA code.
Okay.
Yes, sir, it's just the legal reference right there, 3 has gone away. And then on line 18 of the current policy, it says new line added after that, not limited to, and then they're gonna add some new wording. We're talking about, let me just read off the new policy over there. And other stakeholders concerned with the health and wellness of students, primary responsibilities of the council include, but are not limited to, reviewing the coordinated school health plan, and as necessary, making recommendations as to procedures and programs. That's new language there. On our current policy lines, the bullet points there, 1 through 4, 19 through 28, they're striking that out. And then we have some new language on lines 23. Additionally, each school shall have a healthy school team that is representative of all 8 components of the CSH program. The team members shall consist of a principal, teacher, staff, students, parents, and community members, with at least half the team members being non-school personnel. You see a legal citation there, so that's following the law. So that's where those 1 through 4, it replaced it with that sentence, and it's outlining who the team members shall be. We turn the page again. Everything on the second page of the new policy are legal citation changes that'll be at the end of the policy, except on line 11 of the new policy, include any special exemptions for infrequent school-sponsored fundraisers here, and that does not apply to us. So, if you go to the final page on the proposed change policy, once again, there's 3 legal references, line 7, 9, and 17, and it's just the citations there at the very end. And then Tiffany included a copy of the state coordinated school health program policy, and that's all this policy is doing, is taking the State Board of Education policy and putting it into our form that we're using. So there's no real changes, it's just really how it's laid out. It's not changing how we do business. I recommend we approve it with the changes that we make.
I'll make that motion.
Motion by. Got a motion? Second, Mr. Harold. Anyone else?
I just see it like, Mr. Jenkins said, just changing those citations where it's referencing the law changes, or making sure we're identifying the law that speaks to that paragraph or whatever, but we just need to update ours.
Okay. Mr. Harold, you got anything else?
Nope, I'm good, thank you.
Anyone? All in favor, say aye.
Aye.
All opposed? We'll move to alcohol and drug in the workplace.
Okay, this is policy 1.804. No changes all the way down to lines, or to the bottom of our current policy. After lines 22, they're adding a section, physical examination screening based upon reasonable suspicion. So lines 24 through 28, I'll read it. Whenever the director or his or her authorized designee reasonably suspects that an employee's work performance or on-the-job behavior may have been affected in any way by illegal drugs or alcohol, or that an employee has otherwise violated this policy, alcohol and drugs in the workplace, the employee may be required to submit a breath and or urine sample for drug and alcohol testing as detailed in policy 5.403, drug and alcohol testing for employees. So that is added to the drug and alcohol in the workplace. That's no different than what we've always done in my 30 years of education. If we suspect someone being under the influence while at work, then we will follow the protocol and always have. They're just adding it to in policy here, so I recommend we adopt it as recommended.
Make a motion.
Second.
Got a motion with Mr. Brackett, second by Ms. Jackson. Mr. Brackett?
No.
Ms. Jackson?
Nothing further.
Anyone else? All in favor say aye.
Aye.
All opposed? Okay. Moving over to personnel records.
Okay, personnel records, 5.114. They are recommended adding language. If you look at our current policy, we have 5 things there that are to be included in the personnel record. Now they're recommending we add number 6. And number 6 on the updated copy says disciplinary action as appropriate and any response from the employee. So in other words, if discipline comes from the director of school's office for any employee, there's always a letter placed in that employee's permanent file, and the employee, by law, has an opportunity to respond. They have to sign it. That don't mean they agree with the disposition of the discipline. And then as an employee, they are able to draft their own version of the events or why they agree or disagree with it, and then that can accompany whatever that letter is, and it will stay in their permanent file. And that's just, it's good practice, it's part of the law, and that's what TSBA recommends, their attorneys recommend, and I say we add line 6 and move forward and approve.
Motion from Mr. Jones, second from Mr. Brackett. Mr. Clown?
No, sir.
Mr. Brackett?
No, sir.
Anyone else?
Just a question, are all of these files housed at central office or in the schools where they?
No, we house personnel records here, their permanent records are here.
Okay, so evaluations are in that file, because it says that.
We have digital copies of everyone's evaluations through TD Compass.
Okay.
And those,
Okay, that
like,
was-
in-school evaluations, the principals perform, they stay in their school folder.
Okay, thank you.
Anyone else? All in favor say aye. Aye. All opposed? Okay. Separation practices for tenured teachers. Mr.
Okay.
Jennings.
This one right here is definitely a change in how policies are, and it's gonna impact the next 3 policies in our packet. So, this is new. It's been in practice to some degree in places, but TSBA is recommending this. So what we're gonna do is we're gonna look at, our current policy is gonna remain in place, and before all of that, so before number 1, suspension pending an investigation, then TSBA and their attorneys are recommending this language, and it's lines 1 through 12 on the updated policy. So allegations requiring temporary removal from duty. Okay, if an investigation of an employee's conduct is required, the director of schools shall determine whether to temporarily modify the employee's work status based on concerns for safety or to minimize disruption to the educational environment. This may include, but is not limited to, reassignment to alternative duties, placement on administrative leave with pay, because I'll go back to that, or temporary removal from the school setting. Such action shall not be considered disciplinary in nature, but rather a precautionary measure until a determination can be made regarding an inappropriate return to duties or the imposition of disciplinary action, which could include suspension without pay. I think the best way to summarize this, and our principals in the room understand it probably better than anyone, there's times when reports are made within a school building, and the principal has a pretty good idea of what they think transpired, but they use what's called a summary suspension to get a little space, so whatever the kid that's involved in that, one way or the other, give them some time, and then it gives them some time to collect more information. So that's not a punitive measure. Now, when they're on summary suspension, they find out that they did in fact do a major infraction or whatever, then consequences can be assigned. But sometimes it's to protect that individual, that they would place them on this temporary leave. And like I said, at any time during that leave, they're still on pay, but if any time during that you find out that they were at fault, and we're going back to talking about employees, then you can initiate an official suspension, and all those are without pay. So sometimes it's in the employee's best interest, because the rumor mills or whatever may be affecting them or impacting the environment, that we allow them to work at an alternate location, for an example, until we have an outside entity investigate, so on and so forth. So that would be added to this policy before number 1 of our old policy, and then everything else stays the same. All suspensions are still without pay. You still have the same consequence, up to a 3-day suspension without pay, or they can go before the board. None of that has changed. So.
Like this 1 through 12, when you're talking about placement on administrative leave with pay and temporary removal from the school setting, like is there a maximum amount of time you can do that? Or?
They do not put a cap. TSBA does not put a cap on that. Of course, and it could vary depending on the circumstance and how volatile things may be around it, because sometimes false allegations are made and people respond to it, and it takes time to pull outside agencies in and for people to understand that it's not a conspiracy. We are, in fact, doing this to protect our employee that we believe in this case was blameless, generally, or you would just, if you thought they were guilty and you had evidence, you would go ahead and suspend them without pay. But this is for a time when you think it's, that they will be exonerated, basically.
You need more information with that.
Correct. And like I said, you still have to do the right thing, but this is not putting a ding on anybody's record based on an allegation. And it's not gonna be something that you use frequently, probably, but it's something that does get utilized in the school system, and they're putting it in policy. So I recommend we adopt it as they recommend.
Did you make the motion?
Or did you make the motion?
You did.
Okay.
Mr. Brackett?
No.
Mr. Harold?
No.
Anyone else? All in favor say aye.
Aye.
All opposed? Who seconded, who made? Separation practices for non-tenured teachers.
Okay, this is exactly the same as for the tenured teacher one that we just approved, that would be doing the same language. So if they were classified personnel, or in this case, these are teachers, but these are non-tenured teachers, you would still give them the same, put them on the same playing field. So if someone made allegations, or if there was some reason that you needed to remove them from that environment, you could do so. So no other changes in the policy, everything else is the same.
Make a motion approved.
Second.
Mr. Brackett?
Nope.
Ms. Jackson?
No, sir.
Anyone else? All in favor say aye.
Aye.
All opposed? Ayes, carried.
Okay, moving on to 5.202. This one is the same as far as the top line. This is separation practices for non-certified employees. So these are our classified employees. They would still have the administration would have the option to temporary removal from duty, just the exact same wording as in the old policy. And then there's some changes further down the page under suspension. That's at the top of the page on our current policy, because we didn't have that other. But under no circumstance shall a director of school suspend an employee with pay, and then you say the new line added, if a Department of Children's Services or criminal investigation is pending. So if you have a classified person and we have done a referral to DCS or the Sheriff's Department detectives or whomever may be investigating it, then that just clarifies that you cannot suspend them with pay if that's the case. So everything that we just adopted on the previous two policies can't be applied if you're having DCS investigate something. You go ahead and suspend without pay until they are either charged or exonerated from
Anyone else? Mr. Cantrell, anything?
No, sir.
Ms. Jackson?
Just a comment on what Mr. Jenkins just read. It says, as a follow-up, if reinstated, the employee shall be paid full salary for the period of suspension unless suspension without pay is deemed to be an appropriate penalty. So if they're not guilty or found not guilty of whatever.
Well, and sometimes, and just to verify for everybody, sometimes somebody is guilty, but it doesn't require, removal from the position. And if somebody's found guilty of doing something, and it, no matter whom investigates it, we get a report, we wait till we have all the information from the outside agencies, and we make a determination as to appropriate consequence for that action. And oftentimes, dealing with kids, it is removable and they lose their position, but sometimes it's things that are, not heinous or aggressive in nature that they get less than, and they may lose days without pay as part of their consequence. And a permanent letter in their file that they can respond to in writing, all of that can be part of the discipline, procedure. So not everything is, and, also, these all get reported to the State Board of Education. And sometimes we have to wait on the State Board of Education to rule on the consequences of those said behaviors, and then sometimes you send it in, you think, well, and the State Board of Education chooses not to issue any punishment, so you have that there as well. So, just want to be transparent in all this.
That's all, Mr. Chairman.
Anyone else? All in favor say aye.
Aye.
All opposed?
Sick leave, 5.302. And I've got some, changes here. So if you'll go through our current policy, everything stays the same until line 10. A falsified statement shall be grounds for dismissal, that's in our current policy. And then after that, an employee absent for 5 consecutive working days shall submit a doctor's statement verifying illness or injury of the employee or immediate family member. So that is TSBA's recommendation to add that. You know, employees earn sick leave, and generally, if an employee's in good standing and we don't feel like there's any reason, then we can take that employee's work. But if they miss an extended period of time, then they are recommending that we have a doctor's statement for them or their family member. And then, lines 13 and 14 are new. Frequent use and or suspected misuse of sick leave by an employee are sufficient grounds for requiring a physician's certificate stating the reason for absences. Those are new lines, and it's similar, honestly, to our student, expectations, and it places that. Yes, they are employees, but yes, in a company this large, we do have people that sometimes, sick days are for sickness of yourself or your family members. It's not for vacation or anything else. You have to use vacation days if you're a 260-day employee, but if you're a teacher, you have to use personal days. But if you're going on vacation during the school year, you have to do your personal days or days without pay. And you can't use sick days for those things. And that's just what it's always been, and that's regulated by the state. And this right here puts that into practice. And then if you go down to the bottom on the current policy, they're taking away lines half of 21, 22, 23, 24, 25. Upon termination, an employee's accumulated sick leave. Now, I had Tiffany write TSBA today to clarify that. TSBA is recommending if you terminate a support personnel, that the employee would lose all unused sick leave. They will forfeit that if they get terminated. Our current policy was saying that even if they were terminated, they could roll it into the Tennessee Consolidated Retirement System. Derek?
We talked to TCRS yesterday, and to our knowledge, they're not having any changes to the way they currently operate. system though, when we term somebody, it could be for leaving.
What we're talking about here is if
Yeah.
you fire somebody, let's just say the word, if you terminate somebody, you fire them.
Correct.
Okay.
Currently still, even if that were the case and they went to another TCRS employer, we could certify the number of sick days that they have and they could take those to that employer.
So Derek, let me ask you this, and probably Mandy as well. If we pass this policy as written, would we grandfather current employees in and then new employees, it would be part of their new contract?
So you're saying right now, if we fire somebody, they can take all their days with them?
We could certify those days for them, saying, yes, this is how many they had. And if they went down and applied at the city of Rockwood, then the city of Rockwood could say, yes, we're gonna honor those 10 sick days you had and add them to your bank at the very beginning of your employment. Yes.
Just a question, because this particular section only applies, as I'm reading it, to support personnel. So is it-
Correct.
So is it different for professional employees? So we're just talking about the employees that,
Classified employees.
If you'll refer back to that professional portion, lines 16 through 18 of the current policy, and then I believe on the new one, 20 through 22, describes exactly what I'm talking about
did they,
for teachers, but it also applies to support as well.
We have treated the same, TSBA is saying you don't have to upon termination. And I'm not recommending one way or the other, I'd rather the committee decide if we want to keep it the same. And if some, classified employee does something to get terminated from the position, allow them to accrue those days and take them, if someone chooses to hire them in another system or another state, it doesn't have to be a school system, it could be another state office.
if they have days they hadn't used, I don't have a problem with them, you know, that's one thing they did right, they were on the job instead of using every possible day they could use.
The world I live in, if you get fired, you lose your job. But I've never even heard of that, but I'm not ready to vote on this. I
We're
don't
not paying them
understand
though,
what
right? I mean, we don't pay them for them anyway.
Correct, it's
Like
20 days counts toward a month toward retirement. So you could have a long-term classified employee that does something at year 32 even, and may have 200 days built up, and they do something that we have to fire them over. The question is, you want to fire them and take those 200 days?
Are we looking at termination as a dismissal? Or termination as, I'm going somewhere else,
That is
so
not
my job is
termination.
terminated?
Yeah, termination to me is not firing.
Termination is firing. It does, I mean, I would think that, and we can clarify it through
I think that
TSBA.
needs to be clear.
Yeah, let's just,
Yeah.
like.
Let's bring that one back.
I had a question too on this, back up on line, 10 through 12,
Yes,
where submit a doctor's statement verifying illness or injury, I'm sorry, of employee or immediate family member. I mean,
Kinda seems like we're overstepping our boundaries trying to figure out, hey, what's wrong with your spouse or what's wrong with your kid? I don't know, it just seems like it's kind of an invasion. You know
You
what I
gotta do
mean?
it at TVA.
and we do this with employees that currently we do it with employees that we feel like are
Abusing.
using their days or whatever. It's
I don't think the statement tells what they were there for, it's just they were at this office on this date.
Yeah, but then you're like, well, that's a cardiologist or, you know what I mean?
I have to tell why.
It kind of,
but that's made some multiple days in a row, correct? I mean, that's
5 days.
5 days.
So we're holding this
We're going home with that. We won't stop right there. I'm about policy that.
Ready to make a motion, we end this?
Yes.
I'll make a motion, we end this.
Second. He's usually quick.
All in favor of ending this torment, let's move on to another one. Good.
It's a lot.